Okay, good morning. This is case number 2020-000108, Michigan Alliance for Retired Americans, Detroit Downriver Chapter of the Philip A. Randolph Institute, Charles Robinson, Gerald McMurran, and Jim Peterson as plaintiffs versus Jocelyn Benson in her official capacity as Secretary of State, and Dana Nessel in her official capacity as Attorney General. Counsel, there are many attorneys who are present. What I would ask, if you don't mind, on behalf of the plaintiffs, is if the plaintiff's counsel who is making the argument enter not only his appearances, but acknowledge the appearances of his colleagues.
Good morning, Your Honor. Uzoma Nkwanta. I will be arguing on behalf of the plaintiffs, and I'm joined by my colleagues Jyoti Jasrasaria, Courtney Elgart, Raina Alman Griffin, and Sarah Prescott.
And as I recall, a motion to withdraw was filed on behalf of Ms. Anderson, is that correct?
That's correct.
And I assume there was no objection to it, so pursuant to that request, she is relieved of any and all responsibilities in this case as of that date. On behalf of the defense, please.
Good morning, Your Honor. Assistant Attorney General Heather Meingast and Assistant Attorney General Eric Grill on behalf of Secretary Benson and Attorney General Nessel. I will be making the argument today. However, if there are witnesses, Mr. Grill will be performing those duties.
Okay. So pending before this court are two things. One, a motion for summary disposition, and the other, a renewed motion for preliminary injunction. What I would prefer to do, unless it is strenuously objected to by the parties, is as relates to the motion for preliminary injunction, entertain 5-10 minutes of openings and then allow us to hear from the witnesses so they can be examined, excused, and will not be held in a waiting room unnecessarily while you make your other arguments. Are you comfortable with that, sir?
Yes, Your Honor.
And on behalf of defense, while Ms. Meingast, I know that you are lead counsel, are you and Mr. Gill okay with that?
Eric, are you okay with that?
Yes, Your Honor. Thank you.
Okay. With that in mind, then, if you would make your preliminary argument in support of your renewed motion.
Thank you, Your Honor. Your Honor, the Michigan Alliance for Retired Americans and the individual plaintiffs filed this renewed motion for preliminary injunction because urgent and immediate action is necessary to protect the franchise in the November election. We are past the point of what ifs. There are no more hypotheticals. The worst case scenario is at our doorstep, and the laws that we have challenged, both individually and cumulatively, will deny our plaintiffs and Michigan voters the right to vote in a November election absent injunctive relief. Now, there are three separate provisions that we challenge, and we have presented unrefuted evidence that those three provisions are unconstitutional as applied during this election. First, the ballot receipt deadline. We know that 6,405 voters at least had their ballots rejected because they were delivered to their local clerk's offices after Election Day. We also know that the USPS has acknowledged that Michigan laws and deadlines for receiving absentee ballots and for requesting absentee ballots are incompatible with the USPS's service delivery guidelines. And we finally know that USPS is currently in the throes of operational upheaval, which has resulted in delays that has been acknowledged by both USPS officials, the Secretary of State, and Michigan, the state of Michigan, went so far as to file a lawsuit because of these operational changes and because of the delays that they have caused. The only entity and the only groups that have not yet had their say in court and have not yet been protected from these well-documented delays are the voters and the organizations that serve them. We also challenge the lack of prepaid postage or the requirement that voters pay for postage to the extent there is such a requirement. The Secretary of State has already allocated $2 million to reimburse local city and township clerks for prepaid postage. Whatever state interest may have existed for not providing prepaid postage several months ago has gone out the window. There's no financial interest anymore in not providing. The money is there, and there's no reason why these counties should not be required to provide prepaid postage. The failure to do so will require plaintiffs and our witnesses, like Ms. Gwendolyn Babb, who are high-risk individuals susceptible to severe illness from the coronavirus, to venture out in search of postage, to pay for the fees associated with postage, which is not limited to the 55% stamp, but extends to the other transactional costs that one has to go through to secure postage during a public health pandemic. Lastly, we challenge the ban on ballot delivery assistance. Once again, in the midst of a public health pandemic and in the midst of a public health crisis, when Michigan already permits a variety of individuals, from family members to household members to even in-laws, to return ballots on behalf of other voters, there is no justifiable reason to prevent Michiganders who need such assistance in order to protect their right to vote. You'll hear testimony from Ms. Gwendolyn Babb, who will explain how she was unable to vote in the March election because her ballot arrived on the day of the primary and she didn't have any family members available. She could have asked her neighbor, but Michigan law prevented that. For some odd reason, Michigan law presumes that it is more secure for an in-law to deliver your ballot than it is for a trusted neighbor or a trusted friend. Those distinctions are meaningless. Those distinctions are unexplainable and irrational. You'll also hear evidence and testimony from Dr. Michael Herron, an expert in the field of voter fraud, among many other fields within the political science and quantitative studies field. And he will testify that the incidence of voter fraud is virtually non-existent, both in Michigan and in other states that have actually permitted ballot delivery assistance. He will further explain that the connection between ballot delivery assistance and voter fraud is non-existent because in states that had ballot delivery assistance and permitted it, and then eventually prohibited the practice, there was virtually no change. Voter fraud was non-existent before, and voter fraud was non-existent after. These laws in the upcoming November election, in light of the challenges posed by this public health crisis, in light of the challenges posed by the operational difficulties of the USPS, in light of the delays in mail delivery, in light of everything that voters in Michigan are going through, these laws, as applied to the upcoming election, will violate their right to vote, will place an impermissible burden on the franchise for these voters, and will violate their federal rights, specifically under Section 208 of the Voting Rights Act. For these reasons, and based on the evidence we've presented and the evidence you're about to hear, we ask that this court grant plaintiff's motion for preliminary injunction, or should I say plaintiff's renewed motion for preliminary injunction. Thank you.
Ms. Meigas?
Good morning, Your Honor. Heather Meinguest on behalf of the defendants. Briefly, Your Honor, because I'm sure that you've read the brief. I think with respect to the ballot receipt deadline arguments and statutes, certainly there's a threshold question before this court, as we pointed out in our briefing, and as the House and Senate did as well, that there's a question of whether these as-applied claims do actually survive after the League of Women Voters decision. So there is a question, a threshold type of question for this court to resolve. If the court resolves that there are the as-applied claims can in fact go forward, as you will have seen from our brief, we share concerns with plaintiffs about this particular election and the burden that is going to be imposed on voters in November with respect to making determinations as to how and when to mail their AV ballots. And so, we tend to agree that there is a burden that is higher than than we first thought or first argued in our briefing. And, you know, does seem to be at least an intermediate or heightened burden that would potentially apply in this scenario, at least as applied to the November election. So we have made that point in our brief. And, you know, the argument and the decision on that will certainly depend on whether these as applied claims actually survive review under Legal and Voters. With respect to the ballot assistance or delivery statutes, however you want to phrase those, I don't see the argument, the supplemental arguments that they've offered in the affidavits nor the exhibits aren't really any different than what we saw in the first go around on this. I read those as really the premise of the delivery statutes is that somehow the current pandemic situations or financial conditions of people, you know, make it harder to get assistance. So that's not really any different than what we argued previously on July 8th. From our perspective, the Article 2, Section 4 claim basis for that is not supported by the actual text, as we've explained in our in our briefing, the multiple briefing, the equal protection challenge. You know, the delivery restriction on third-party delivery is still a minimal burden. There isn't really any distinction between the situation now than there is before. I mean, there are other options for voters to contact people. You can contact the clerks. I mean, they phrased it in their complaint as this is about people who need last-minute assistance. Well, last-minute assistance can be provided through contacting the clerk's office. Also, as we pointed out with respect to the First Amendment claims for the organizational plaintiffs, you know, it's easy enough for them to become involved in this process through appointment as assistants through a clerk's office. And I would expect that many voter groups and Get Out the Vote organizations are in fact doing just the same. On the preemption argument, I would simply reincorporate our arguments for before. It's the obstacle, the delivery ban or the prohibition on third-party voters does not stand as an obstacle to Section 208 because voters still have a range of choices within which to exercise their right to receive assistance. As to the postage requirement, you know, that was not argued in brief before. So those are new, but again, it's, you know, from our perspective, I'm not sure that any of that survives the rejection of the claims in Legal and Voters. And with respect to the suggestion that it would be fine to enjoin the state because we have federal money to spend, as we pointed out, you know, I'm not sure how you enjoin all the local counties to accept our money and to, you know, that's not a reason. We still have legitimate interest supporting the postage requirement as explained in our briefing. And the fact that we are going, it's a policy decision, or going to be able to make federal money available for reimbursement doesn't undermine the fact is a policy decision and still supports, doesn't detract from our arguments that this is a minimal burden that's supported by state interests. So just sort of in brief, that's kind of where we're at on the arguments, Your Honor.
Okay. May I ask, is there a factual dispute between the plaintiffs and the defendants as to whether or not, as to the facts in the affidavit regarding voter fraud or the offer of proof? In other words, is it the contention of is it agreed between the parties that the instances of voter fraud are, as they've been purported, is not a significant issue as relates to absent votes, and that presence or absence of voter assistance has not been empirically shown to be connected to an increase in voter fraud?
I was going to say,
go ahead, Eric.
It is my intention to ask Dr. Herron some questions this morning, just to, I think, clarify the scope of his conclusions. So we can make that statement just yet.
Your Honor, if I may respond to that, I believe
You don't have to. If they don't agree, it doesn't matter. And apparently they don't. I had thought that you might have gotten together and come up with a statement regarding the empirical data on voter fraud, because that data is what it is. But apparently you have not had that opportunity. So we'll have the opportunity to engage in expert witness testimony via Zoom, which in and of itself will be bizarre. But okay, counsel, if you would call your first witness, please.
Certainly, and I'll let Ms. Jess Rosaria call the first witness.
Our first witness is Ms. Gwendolyn Babb.
And if we would admit her into the Zoom call. Okay. Ms. Babb, if you would raise your right hand, ma'am. Do you swear or affirm the testimony you are about to give in the cause pending before this court will be the truth?
Yes.
Okay. Thank you, ma'am. During the course of this examination, both the only live mics should be those of questioning counsel, myself, and the witness. I ask you to stay unmuted because if you have to make an objection, by the time you unmuted yourself, it would never be heard. Our fortunate court reporter is encouraged if at any point in time people are speaking over each other in a way that compromises her record, to immediately tell us. So I guess I should have said her mic should also be unmuted, although I know that's unusual, but I can't think of another way to manage it. Madam Court Reporter, do you have an idea about how to manage that problem other than leaving yourself unmuted? I need the court reporter unmuted because I haven't heard an answer.
I think the way you said it is fine, Judge.
Okay, thank you very much. With that, we will proceed with the examination of Ms. Babb. Ma'am, while you are being questioned, at any point in time, if you do not hear a question, ask the questioner to repeat it. If you don't understand it, please do the same. Additionally, realize that even if we were in live court, shaking your head, yes or no, will not give the court reporter an official answer. So we need for you to answer yes or no when it's that kind of question, and to use the traditional words that our mothers wanted us to use, yes and no, rather than that lovely phrase, uh-huh and uh-uh. Okay, thank you.
Yes.
And would you proceed, counsel?
Your Honor. Good morning, Ms. Babb.
Good morning.
Could you please state your full name for the record?
Gwendolyn Babb.
Where do you live, Ms. Babb?
Counsel?
Yes.
You really don't want Ms. Babb to recite her physical address. How about a city and a state and a zip code? Can we all agree to that? This is a public record, and while I don't think anything would happen, she doesn't want extra visitors.
Absolutely. We appreciate that. Ms. Babb, could you please give us your city, state, and zip code?
Detroit, Michigan, 48227.
How long have you lived in Detroit?
63 years.
Is that your whole life, Ms. Babb?
Yes, it is.
And who do you currently live with?
My son.
Are you registered to vote in Michigan?
Yes, I am.
And how long have you been registered to vote in Michigan?
I'm since 1975.
Do you vote regularly?
Yes, I do.
How do you typically cast your ballot?
In the past 2 years, I've cast my ballot, my absentee ballot.
Why is that?
I've been recently diagnosed as disabled. My physical health doesn't allow me to go and stand in the line and vote as I had in the past.
Do you use assistance to get around?
Yes, I need walking assistance with a walker as well as a cane. I use either one.
How do you usually leave the house?
I leave the house with someone due to my assistance. I need assistance getting to the car, and generally I have someone with me that can help me with my walker, or or assist me as I'm going with my use my cane.
Do you drive, Ms. Babb?
Yes, I drive very sporadically.
And are you able to leave the house and drive on your own, typically?
No, I'm not. I must have someone with me when I'm in the vehicle due to my inability to get out and maneuver without assistance.
Thank you. I'd like to turn to the Michigan presidential primary this March. Do you remember what date that primary took place?
March the 10th.
Did you plan to vote in that election?
Yes, I did.
How did you plan to cast your ballot?
By absentee ballot.
When did you request your absentee ballot for the March primary?
Well, because I had been receiving the absentee ballot the year before during the election, I didn't put in another personal request for that particular one. I just was expecting to still be on the roll call for an absentee ballot.
So are you on the permanent absentee voter list?
Yes, I am, prior to that election.
And as someone who's on that list, when do you typically receive your absentee ballot?
2 weeks to 10 days prior to the election.
When did you receive your absentee ballot for the March 10th primary?
On March the 10th.
And that was in the mail?
Yes.
What were your options to cast your ballot after you received it on March 10th?
My only option at that time was to have it taken to the city clerk's office.
Was it possible for you to mail it at that point?
No, it was not.
Why is that?
At the time, the absentee ballot had to be inside the city clerk's office by the end of election day in order to be your vote to be counted.
Could you have had someone else deliver your ballot for you?
On that particular day, no, it was no way I had anyone that the city clerks allowed, mandated by the state of Michigan, to deliver my absentee ballot to the clerk's office.
And you lived with your son at the time, correct?
Yes.
Was your son available to help you?
No, my son he was at work. When the mail arrived, he had already left for work. And I could not have him to take me or take it.
Who would you have wanted to ask for help that day?
I would have loved to ask my neighbor, who I've been knowing for over 30 years, to take it. Him and his wife live next door. I would have loved to ask them to deliver it for me, but under the current circumstances, that wasn't an option that I had at that time.
And why didn't you have that option?
I didn't have that option because according to the Michigan laws on my absentee ballot is where I actually read it. There are certain individuals that are allowed to take your ballot back or it would be voided. And that in that instance, I didn't have, my son wasn't available, my daughter wasn't available, or nor was my grandchildren available. And I have no in-laws, so I was therefore unable to get it to the city clerk's office on that particular day.
Was there any way that you could have returned the ballot on your own?
No, there was not.
Were you able to cast a ballot in the March election?
No, I was not.
And how did that make you feel?
I really was upset. I felt that is a way of keeping me from voting, and I feel that I have the right as a citizen. I've paid my way, and I felt that my vote was being suppressed because I could not vote at that time.
I'd like to turn to the August primary, but knowing first that a lot has changed since March, I just first wanted to ask you, are you concerned about COVID-19?
Yes, I am very concerned about COVID-19.
Why is that?
I have several underlying health conditions that allow me, that puts me in harm's way if I should have COVID-19, if I should come in contact with it.
Thank you. Okay, so turning to the August primary, do you remember what date the August primary took place?
August the 4th.
Did you plan to vote in that election?
Yes, I did plan to vote then.
And how did you plan to cast your ballot?
By absentee ballot.
When did you request an absentee ballot for the August election?
Well, this year they sent out applications to everyone, so I reapplied the application, and that was around in June. I received an application, so I resubmitted it, requesting absentee ballot.
How did you prepare for voting absentee this August?
I alerted my daughter, my son, that this time, whenever I received it, someone would have to drop my voter ballot off at the clerk's office. If it came in enough time where I could mail it, I would be okay. But in the event that it came within any length of time, I give myself 7 days with the way my currently mail has been going. If it comes within that 7-day period, I want someone to drop my ballot off at the city clerk's office. I want to be counted.
When did you receive your absentee ballot for the August primary?
1 week before August the 4th. It came that Tuesday.
Have you been experiencing mail delays this year besides the ballot?
Yes, I was, especially I was looking for my ballot in particular, and the week before it came, I didn't receive any mail that Wednesday, Thursday, Thursday, Friday, Saturday, I didn't receive any mail. And then Sunday, I received mail, which is very odd because I never really get mail. I never got mail on Sunday, but I did that Sunday. And then the following Tuesday is when my ballot came. And so knowing that the mail had been delayed for whatever reason those days, I said I would not entrust my ballot in the mail. So that's when I had my daughter or had my son, and to know that I needed it to be delivered.
When was your daughter available to help you return your ballot?
Monday, March the 3rd.
Is that, sorry, August?
August, I'm sorry, August the 3rd, I'm sorry.
And why was she available that day?
Her off days was that particular day, she was off. And she was able to assist in getting my ballot to the city clerk's office.
Were you able to go with her to the clerk's office that day?
No, I was not. I was experiencing a shortness of breath that day. My initial idea was to go with her, but that particular day I was having a shortness of breath and it was difficult to maneuver, so I just asked her to take it for me.
If you had been able to go with your daughter, would you have been able to go inside the clerk's office to return the ballot?
Not without assistance. I would have had to have someone help me take my walker out of the car, or, assist me getting out with my cane. And it would have been a challenge, yes.
In general, are you comfortable getting in the car with a non-family member?
No.
Why is that?
I have a series of health issues, and I have a COPD, which causes me to be out of breath when I walk for long distances. And it's a lot of time, it's frightening to people when you get in there and you're trying to catch your breath, and I'm uncomfortable with it. When I'm breathing, shortness and trying to catch my breath and looking for an inhaler. And so it's not what a position I like to put others in.
And have you been social distancing during COVID-19?
Yes, I have. I have been quarantined in this house. I went out only a few times since March. I know since April. I might have been out maybe a handful of times.
Great. Well, let's turn to November. How do you plan to cast your ballot this November?
Absentee ballot.
And have you requested an absentee ballot for November?
No, I did not request one. Another one, other than when I sent in my application, I haven't re-requested. Once you're on the absentee ballot list, my understanding was that you would be there unless otherwise, because I'm there by being disabled as well as my age. So my understanding was that I didn't have to request one every election. Now, since COVID-19, there have been several, since COVID-19, there have been several changes where they were sending out, like I said, a mass amount of applications came out. And, but I did complete then. I have not contacted the clerk's office since then, no.
When do you plan to submit your absentee ballot?
As soon as it arrives. Once I realize that the state of Michigan has early voting, as soon as I get it, I plan to complete it and return it.
And how do you plan to return your ballot?
If it allows me enough time to mail it, I would love to mail it. But if it's not here within what I think is 10 days before the election, I will definitely have it taken to the city clerk's office.
How do you feel about voting absentee this November?
I am fearful due to my mail delivery has really changed this summer. Prior to now, I didn't think twice about putting it in the mail, but I have my hesitancy due to the delays of delivery that I've been receiving. But I would love to be independent, complete it, put it in the mail, have it counted. That's what would be my ideal.
Thank you, Ms. Babb. Your Honor, would you like to cover anything before I pass the witness?
Not at all.
Thank you. I pass the witness.
Good morning, ma'am.
Good morning.
My name is Eric Grill. I'm with the Michigan Department of Attorney General, and I'm one of the lawyers representing the defendants in this matter. I do have a couple of questions for you. I want to start with the March presidential primary. What contact did you have with your clerk leading up to when you received your ballot?
What contact did I have? Other than applying for absentee ballot, I hadn't had any contact with them.
Okay, so in the weeks and days leading up to the presidential primary and the ballot didn't arrive, did you?
Oh, I did call and inquire.
Okay.
I received one, but that was the maximum of it. And
Okay,
I was informed that I would receive one.
When did you first contact the clerk before the March presidential primary about where your ballot was?
I contacted them it had to be maybe just before it arrived, because I contacted them maybe 2 weeks outside of not receiving it before March the 10th.
Okay. And that was just the one time, or did you call multiple times?
No, I just called the one time.
Okay. What explanation did you receive about why your ballot hadn't arrived yet?
She said I would be receiving it. I was on the list to receive one because I called to see did I need to call and ask for one. She said I was on the list. I would be receiving it.
Okay. Did they explain why you hadn't received it by that point?
No, she did not.
Okay. Did you ever receive an explanation from anyone about why your ballot arrived on the day of the election?
No, I did not. And I did call after it came on the 10th. I did call to express that my not being able to vote and how upsetting I was that it didn't arrive until the 10th and that I was not able to cast a ballot due to certain health conditions for me, and I didn't get to vote. Yes, I did call and do that.
Did you ever receive any information about whether the clerk was late mailing it, whether there was a problem with the post office, whether your local mail delivery person had a problem?
I never received anything. I spoke to a young lady, told her my how upset I was due to me not being able to vote, gave her my name, my information, and I never heard anything back from them, no explanation, anything.
Okay. And now the March 10th presidential primary, that was, I know it seems like a long time ago now, but that was before all of the, before the isolation, right?
Yes.
So would you agree with me that delays or mail delays can still happen even outside of a pandemic?
Yes, I would agree with you, but I know since the pandemic, it has been a lot more frequently. I'll state that.
Okay. One other quick question about the March presidential primary. Had your ballot arrived in time, did you have access to postage to return your ballot?
If it had arrived in time?
Yes.
Yes.
Okay. Let's move ahead to the August primary. You said that your ballot arrived the Tuesday before election, so that was a solid 7 days before the election. Is that correct?
Correct.
So you could have, you had the option available to you to have someone help you deliver that ballot, one of your friends, I'm sorry, excuse me, one of your family members, your immediate family members, on that day, that Tuesday, correct?
Not that particular day, no. I had both my children work.
Right. Let me rephrase my question. Just specifically, I know that your children had schedules and other things, but the option was available to you. You could have, had they been available and had the time, had them deliver that ballot that Tuesday, correct?
No, that's incorrect.
Why
Not
is
that Tuesday. That's because my mail generally runs here between 2 p.m. and 4 p.m. Both my children are already gone to work by 2 p.m. or 4 p.m. So there's no way I could have had it returned that day, and it didn't come till after they were gone to work.
Okay. Your daughter was off the next Tuesday, right? The day of the election?
No, she wasn't off Tuesday. She was off the Monday.
She was off the Monday before the election. I'm sorry.
Yes, she was.
So if your daughter had been off that Tuesday that you received your ballot, she could have taken you that day. Is that fair to say?
Yes, she could have, maybe. I don't know. My daughter has, the reason I say maybe, she has 7 children. So.
No, I understand. So for these next few questions here, my premise here is that if your daughter or your son or somebody was not working that day and they had no other schedule obligations, if they were available to you, so that's my premise here for these next several questions. Do you understand?
Okay.
So if we accept that as a hypothetical, they could also have taken you that Wednesday, the next day after you received your ballot, correct?
Object to this questioning, Your Honor, assuming hypothetical is not in evidence.
Okay, and I'd love it if you could, but you can't. Your colleague can make any objection she wants, but.
Objection. These questions are hypothetical.
Okay, that's not a overruled.
Okay. Do you remember my question, ma'am?
Yes.
Okay. What is the answer?
Yes.
Okay. And then similarly for Thursday, if your children weren't working and there were no other schedule obligations, they could have taken you to deliver the ballot on Thursday.
Yes, if that is the
Giving
case.
facts, not in evidence.
Okay, let's just assume that I understand that if somebody had a day off and didn't have a kid, they could take her.
Yeah.
We got that.
Okay, I'll move on, Your Honor.
All right.
Ms. Babb, do you know where your clerk's drop box is for ballots?
Yes, I do.
Okay. Have you ever used the drop box before?
No, I have not.
Okay. Is there a particular reason why you do not use your clerk's drop box?
I value my vote. I value having the opportunity to vote. I like to make sure it goes where it needs to be. And I like to put it in from my hand or someone I trust hand and to the clerk's hand, our office. And therefore I know my vote should be counted.
Okay. If absolutely necessary, could you have someone, not necessarily a family member, but a friend or a trusted neighbor, drive you to the drop box to deposit your ballot?
Again, with my breathing scenario, it would have to be someone that I really, maybe my neighbor, yes, I would, but I'm a prideful young lady, Black lady, I know, and I value my right to vote. There are not many things that I still can do, and I value my right to vote. I don't entrust my ballot with just anyone. I would, if I knew that my neighbor, yes. Just anyone off the street, no. Does that answer the question, sir?
I think so. We're talking about driving you to the drop box, right?
Right. The drop box, yes.
Okay. And just to, as I understand your testimony, because you planned ahead, your daughter was able to take you to the clerk's office and deliver your ballot on the Monday before the August primary. Is that correct?
She didn't take me. She took the ballot for me.
Okay. Were you in the car with her to the clerk's office?
No, I was not able to go.
Okay. And understanding that your ballot arrived on the Tuesday before the August primary, but at that time, did you have postage available to you to return your ballot by mail had you chosen to take that approach?
Yes.
Okay. And now turning ahead to the November election upcoming here. Do you expect to have postage available to you to return your absent voter ballot when it arrives?
Do I expect to have postage available
Stamps.
to me to mail my ballot back?
Yes.
If it arrives in enough time to be counted, if I can go through the United States Postal Service, you're saying?
Yes.
I'm just trying to get a clarification.
No, that's fine.
Knowing that I want to vote, I would make sure that I would have postage readily available for that. It's very important that I vote. So,
Okay.
yes, I would do that.
Have you made backup plans with your family to deliver your ballot if the ballot arrives too late to mail it?
Yes, I have.
Okay. And I think we asked this before in regards to the August primary, but just to be clear, for the purposes of the upcoming November general election, do you have a friend or a trusted neighbor who could drive you to the drop box?
You've asked that.
No.
Okay. One moment, Your Honor. I think that's all the questions I have, Your Honor. Thank you, ma'am.
On behalf of the plaintiff, do you have anything in redirect?
Yes, I just have a couple of questions, Your Honor. Ms. Babb, you mentioned that you were unable to go with your daughter to return the ballot in August. Is that right?
Yes.
And were you hoping to be able to go with her?
Yes.
Why weren't you able to go with her?
My breathing got off. Sometimes when I'm dressing, getting prepared to do things, my breathing is very shallow. When it becomes shallow, it's hard for me to walk. I get a little off balanced. So at this particular time, I tried to go, but my health, my breathing, my legs were giving me problems, and I was not able to walk to the car to go. So I sent it for those reasons with her.
Is it possible that, is this something that happens to you on regularly?
She's indicated this happens episodically and periodically.
Yes.
Is there more?
Thank you. No further questions.
Brief follow-up, Your Honor. One question.
I can't even imagine. She went over stuff you'd gone over that she went over. But I can't wait to hear this question. That's going to somehow be appropriate.
Ms. Babb, did you ever contact the clerk's office on at any point up to the Friday before the August primary election to have them come
Outside
and
the
pick up your
scope.
ballot?
Thank you.
Thank you.
Ms. Babb, thank you very much. Please be well, and you are excused.
Thank you very much.
Counsel, if you would call your next witness, please.
Plaintiff's call Dr. Michael Herron. Can he be admitted into the room?
Okay, so because the court reporter was probably surprised by this, could you please state your name so that she knows who is now asking questions?
Of course. This is Courtney Elgart for plaintiffs, and we call Dr. Michael Herron to testify.
Mr. Herron, could you raise your right hand, sir? Do you swear or affirm the testimony you're about to give in the cause pending before this court will be the truth?
Yes.
We've explained previously, and I think you probably heard this, that during the course of your questioning, the only open mics will be that of the questioners and the court reporter, myself, and yourself. If at any point in time the court reporter is not able to transcribe what is being said because one of us starts talking over the other of us, she'll immediately let us know. If at any point in time you have either technical difficulties or anything else that interrupts your ability to hear or understand a question, we would ask, of course, that you make that known and the questioner will explain, or we will try to manage the technical difficulty. Do you have any questions, sir?
No, thank you.
All right, you may proceed.
Dr. Herron, can you please state your full name for the court?
Sure. Michael Charles Herron.
What is your role in this case?
I was asked by plaintiff's counsel to prepare an expert report on voter fraud in Michigan.
And I'm going to put plaintiff's exhibit 1 on the screen. The state is stipulated to its admission. We'll see if the technology, is it possible for my screen sharing to be enabled?
I don't think so.
Okay. Well,
I do not believe so. That was
because
ours is.
But it's already, I'll ask him.
Okay, do you mind if I finish?
Oh, sure. I apologize.
Okay, so what you should know is we operate on a secured system.
Mm-hmm.
If in fact, ever in Michigan, at least in the next year or so, you have the need to do what you're trying to do, you need to do a private dep. Then you can do all the screen sharing that you want. But once we come inside the secured system, we have a responsibility of maintaining ourselves and the system from Zoom bombing or anything else.
Absolutely.
So counsel, you have stipulated to the admission of the doctor's report. Is that correct?
It's his CV.
What exhibits, if any, are you going to be offering through this witness?
Just a copy of his CV.
Just that?
Yes.
Okay. Do you, again, counsel, do you stipulate?
We have, Your Honor, to the stipulated to the admission of Dr. Herron's CV.
All right.
Dr.
And
Herron,
counsel, I read it.
okay, great. Then I won't labor on it for too long. Can you, Dr. Herron, please describe your educational background briefly?
I have a bachelor's degree in mathematics and economics from Carnegie Mellon University. I have a master's degree in political science from University of Dayton. I have a master's degree in statistics from Stanford University.
Mr. Herron.
Yes.
You are speaking so fast, I don't understand your words.
I
don't
apologize.
understand anything. I have a bachelor's degree in mathematics and economics from some university. I didn't hear anything you said after that.
Okay, here's a suggestion. There's not going to be a contest as to whether or not he is qualified as an expert, is there?
Your Honor, I guess if we could just, skipping to the chase, Your Honor, I think I would appreciate some clarification as to the scope of the expertise Dr. Herron's being offered. If the
Okay, so let's try this then. Ms. Egbert, would you please indicate in summary fashion, and I know you could do this, for example, if I was going to describe Ms. Meingast and I was going to offer her as an expert, I would say, I would make an offer of proof that Ms. Meingast is a graduate of amazing university as an undergraduate summa cum laude and graduated magna cum laude from X law school, that she has been a practitioner for X number of years, specializing in the areas of A, B, and C. I am offering her now as an expert in management of a public attorney offices. Could you give me something kind of like that?
Sure can.
Okay.
I'm offering Dr. Herron. He has a doctorate in political economy from Stanford University, as well as a master's degree in statistics and political science from the same. He's a professor of government at Dartmouth University and the former chair of the program in quantitative social sciences. His area of expertise is election administration. He has been studying and publishing in the area of election administration for the last 20 years. He's published over 20 articles on election administration in peer-reviewed journals. He is testified as, he's been accepted as a testifying expert on election administration in at least 3 cases. His opinions have been specifically credited by the court in at least 2 of those cases, and he has a particular expertise in voter fraud. And we are offering him, he's submitted 2 peer-reviewed articles on the topic of voter fraud, one relating to the 2016 general election and allegations of fraud in that election, and one relating to the North Carolina 9th Congressional District and the allegations of fraud in that election. And we are submitting him as an expert on election administration and voter fraud.
And you are not purporting that he has done any particularized Michigan research, is that correct?
No, that's not correct. As laid out in his report, he has used his expertise in political science and on the research of voter fraud to review materials and documents from Michigan and has formed an opinion about them.
Okay, so that we're clear, he will be giving particularized Michigan evidence. Mr. Gill?
Brief word, dear Your Honor.
Well, can we do this? Can we accept that he is generally an expert in this area and allow your colleague to put before us the basis of any expert opinion on the basis for his expert opinions as to Michigan? And then you voir dire.
Yeah, I think I understand, Your Honor. Yes, if the idea is Dr. Herron is being offered as an expert generally with specific thoughts about Michigan, and then I can follow up with my examination about shortcomings I think there might be. Yes.
Okay.
I don't know if that was as
Dr.
clear
Herron,
as.
can you,
Okay, so he's accepting his general expertise, and you are now going to further qualify him as relates to the basis of his opinions from Michigan. Your colleague then wants to voir dire, not as to their credibility, but as to whether or not those opinions meet the basic threshold for consideration by a finder of fact.
Correct.
yes. Okay. I'd like to start by having Dr. Herron give a general overview of what he was asked to do in this case and the opinions he's offering, or do you want me to cut straight to the chase with his opinions on Michigan?
Do it in the
Your
most
Honor.
efficacious manner on your client's behalf.
Okay, thank you. Dr. Herron, can you describe for the court what areas you studied for the purposes of this case?
Yes. I studied 3 distinct areas.
What were they?
Those areas are voter fraud in the United States in general. That was the first area. The second area was Michigan in particular. And the third area is related to the relationship between laws on regulating voter assistance and voter fraud.
And when you say voter assistance laws, what do you mean?
In particular, I mean laws that regulate ballot delivery from absentee voters.
What, if any, conclusions did you reach about the prevalence of fraud in the United States?
My conclusions, as written in my expert report, that conclusion is that voter fraud in the United States is rare and does not pose a threat to election integrity in the country.
And what, if any, conclusions?
I don't know if you're speaking, if you are frozen.
Your Honor, was it me that was frozen or Dr. Herron?
Someone was, but we never heard your question. What conclusions?
Dr. Herron, what, if any, conclusions did you reach about the prevalence of fraud in Michigan?
The conclusion I drew was the same as the conclusion I drew about the United States in general, which is that voter fraud is rare.
And what, if any, conclusions did you reach about the relationship between voter assistance laws and voter fraud?
The conclusion I drew in that area was that I didn't find any evidence that there is a relationship between laws regulating between absentee voter assistance and voter fraud.
Sorry, my internet is cutting out, so there's a delay. Okay, so you've mentioned voter fraud a few times. What is your definition of voter fraud?
I would say that voter fraud is an intentional act of deception with the aim of subverting electoral processes.
And is there a difference between something that's illegal and something that's fraudulent in the context of elections?
Yes.
And can you explain what that difference is in the context of elections?
Yes. In elections, elections are highly regulated affairs where procedures that voters have to follow are regulated by state laws, in some sense local laws, and an individual could violate one of these laws, violate a procedure, but not do that in a fraudulent way.
What are examples of things you categorized as voter fraud in your report?
So I'll just give a few examples. One example is voter impersonation. That's when an individual votes using or attempting or actually succeeding in using the registration records of another individual. Another example is in, for example, like a presidential election, voting in multiple jurisdictions. And a third example could be registering to vote with an address that is not the individual's actual address.
Okay, thank you. And so we're here in Michigan, so to speak. So we'll talk about Michigan specifically. How did you approach studying the prevalence of voter fraud in Michigan?
To study voter fraud in Michigan, I created a database of potential voter fraud incidents, and I drew my conclusions from that database, augmented as well by I would say, a national database that exists that published or created by the Heritage Foundation. It's an interest group. So my database augmented with theirs, and I drew my conclusions from that and from what I could review about government documents.
And why did you decide to build your own database?
Because in general in the United States, as is well known, there are not central repositories of official voter fraud incidents. And here I'm using incidents in a general sense. An incident could be a conviction of a crime. It could be an indictment. It could be an allegation. There are no official national databases like that. There are some states, Michigan, to my understanding, is not one of them, that keeps track of election integrity issues in a systematic way. And because of that, the lack of all those things, I created my own.
And is this a methodology that's commonly used in your field?
Yes, if you look in my expert report, there are examples of people who have done similar things. Dr. Laura Medidi has done this, and there are other examples in my expert report of individuals essentially creating their own databases when they try to understand the scope of voter fraud in any particular jurisdiction.
Okay, counsel, at this point, the record does not tell us, it tells us that he created a database, but the record at this point does not tell us how he created that database so that the court could make a determination of whether he followed the appropriate methodology within his field of study.
Sure, well, let's, that'll be my next question. How did you build a database?
So because there aren't, as I already explained, because of the need to do this, I hired an assistant, which is something I regularly do in my academic work. I would say probably all of my papers involve hired research assistants. I hired an assistant to search newspaper records and for the 5 most common or high circulation outlets in Michigan, and to search them very broadly for discussions of voter fraud. And I asked her to also augment all of her results with information from the Heritage Foundation database, which I earlier mentioned. And I asked her in general to attempt to learn everything she can about incidents. Again, I'm using incidents very broadly, about voter fraud in Michigan.
And how did you direct the way she would search for incidents of voter fraud?
I told her exactly what I wanted her to search for. I gave her a bunch of search terms. Those are in my expert report. One of them is certainly voter fraud. And I gave her all of these terms because it's well known in the field that not all instances of voter fraud might be labeled the same way. And I wanted to make sure that the net was cast as widely as possible.
And to circle back, so this methodology you now described in more detail of searching news articles and public documents, is that commonly used in your field to research the prevalence of voter fraud?
Yes, I remember the other example. It's Justin Levitt. That was in my expert report. And I would say in general, in political science, when people are trying to find evidence of like the extent to which some event occurs, that when there aren't official databases, we have to look for records that might show them. And looking at newspapers is something, I'm certainly not the first person to do this.
And were these studies, some of these studies in peer-reviewed journals?
Yes, and they're in books, and they are considered standard in the election administration field.
Did you focus on a particular time frame in conducting your research?
Yes, I did.
What was that time frame?
The time frame was 2012 through 2020. And the reason I chose this is because I of course, am trying to say something about the condition or the frequency of voter fraud in Michigan now. And so I looked in the historical record, and whenever you do an exercise like this, there's always tension between how recent you want the searching to be, because recent is good because it's more contemporary, but also looking back is good as well because it gives more depth. And so the tension is I want to be as close as possible to contemporary circumstances, but also allow some depth. Too much depth raises questions about comparability. If I were to report about incidents in any state, say 30 years ago, questions would come up as to whether they're germane as to the current state of Michigan, for example. So I have to, in this, always draw a line. And the line I drew was in 2012, and that's a presidential election year.
And what type of voter fraud incidents did you include in your database?
Well, I asked my assistant, as I described earlier, to cast a wide net. So I would say I instructed her explicitly that when she did her searching, that she was to treat as effectively a voter fraud incident, anything involving a conviction or a trial or an indictment, or even an accusation. That's always sort of risky because lots of things are accused, but I wanted her to be, at least there are accusations about all sorts of things, but I wanted her to really be broad. And so those are the instructions I gave her.
And after your research assistant compiled incidents, did you review and ultimately make the decision about what would be included in your database?
Yes, I read everything.
And based on your research, what conclusion did you come to about the prevalence of voting fraud in Michigan?
It's rare.
Now, earlier you said that there were no government reports compiling voter fraud in Michigan. Did you review any documents from Secretary Benson or other election officials discussing the prevalence of voter fraud in Michigan?
I did, and I attempted, as I described in my excerpt report, to find documents that the Attorney General has published, thinking that perhaps there are these regular assessments about election integrity, and the same for the Secretary of State. It's to my understanding that these documents don't exist or certainly aren't publicly available. So what I was able to find was written and spoken testimony by Secretary of Benson to, I believe it's a subcommittee at the United States House. I don't remember whether it's a committee or a subcommittee, but it was testimony at the U.S. House. And
in that testimony, did anything in Secretary Benson's comments stand out to you?
Yes. There were two things I think that struck me. One was that, and I believe this was in her spoken testimony, it was of course remote. That testimony used the adjective infinitesimal to refer to evidence of voter fraud in Michigan, and Secretary of Benson actually talked about in her testimony not just Michigan, but also other states that use that are intense mail-in states, and she referred to again, the adjective she used was infinitesimal. And the second point that struck me is that in her written testimony to the House, Secretary of Benson discussed a set of local elections in Michigan that took place in May. And Secretary Benson mentioned that one, turnout in those local elections was, I believe it was twice as high as in the previous set of local elections. Another point she made was that the elections were conducted almost entirely via mail. And those 2 points are important to me, again, in this sort of casting a wide net perspective, in the sense that if there's an opportunity for voter fraud, last May, I think, would have been a logical place for one, voter fraud related to absentee voting. And then Secretary Benson said, and obviously I don't have my report in front of me, so I believe the exact quote was, there were 0 reports of voter fraud. I don't know if she said 0 reports of fraud or 0 reports of voter fraud, but I know she said 0 reports. And so that's how I would sort of summarize the written testimony that I reviewed for my expert report.
And is it common for experts in your field who are researching the prevalence of voter fraud to look to and consider the opinions of election administrators?
Yes, it is. In my exit report, I even discuss some research programs that involve contacting election administrators and asking them about their experiences with voter fraud. I would say it's one of the methods that people have used. And I would say in political science in general, people or scholars look to official statements made by government officials, especially because this is a situation where the government officials might have very good data that aren't publicly available. And so their assessments about these data or these situations are valuable.
And is Secretary Benson's conclusions about the rare occurrence of voter fraud in Michigan consistent with your own observations?
Yes, I would say that all of my observations the summary of my observations from my expert report are all similar in the sense that the conclusions I drew are similar to the conclusions, are really the same as Secretary Benson has stated about Michigan, which is that voter fraud is rare.
Okay, so you were also asked to look specifically at the relationship between ballot collection laws and voter fraud as well, correct?
Yes, that's correct. That was the third point that we talked about a few minutes ago.
Is ballot collection a form of voter fraud?
No.
Why not?
Because earlier in my testimony, I noted that voter fraud involves an intentional act of deception aimed at subverting an electoral process or electoral processes. And ballot collection can be conducted in a way, or ballot delivery can be conducted in a way that is neither intentional nor that is not intentionally deceptive.
Would you characterize it as voter fraud if a voter asks their neighbor to return their completed ballot on their behalf and the neighbor does so?
No, because that is not an act of willful deception or intentional deception aimed to subvert an electoral process.
And how did you approach studying the relationship between ballot collection laws and fraud?
It occurred to me that to do that, it would be useful for my exit report to look beyond Michigan and to identify some states whose laws had changed in the period of interest, which, as I earlier said, was 2012 to 2020. So I identified 2 states that are like this, Arizona and Montana. Both of those states changed their election laws between 2012 and 2020 to make ballot collection or delivery, to make it, to prohibit it. These are what you'd call in political science, or at least social science more broadly, natural experiments. In social science, we can't dictate when states change their laws, but sometimes they do. And so we can look what happens before and what happens after and try to assess whether there are any systematic changes before and after. And so I looked at those 2 states, Arizona and Montana. And I also, to finish answering this question, looked at Wisconsin because Wisconsin didn't have a change in its election laws regarding ballot delivery, but they did allow it. and do allow it through 2012 through 2020. So I thought that was another useful place for me to study the relationship between laws regulating voter assistance and voter fraud.
And how did you study the prevalence of voting fraud in Wisconsin, Arizona, and Montana?
Essentially, I repeated the same practice. I repeated the practice that I did in Michigan. In those 3 states as well, I'm unaware of sort of systematic documentation from government officials as to election integrity investigations. I should mention, like New Hampshire, for example, does these things. So it's a very different research environment in the state like that. So I asked my research assistant to do all of the searches again in those other environments. I repeated the process. I've read everything, and I've read what government documents I could find, and I built databases of voter fraud, also augmenting them by what I could find in the Heritage Foundation database, and that's how I worked in those 3 states.
And what did you observe regarding the prevalence of voting fraud in Wisconsin, Arizona, and Montana?
I found that
Ms. Elbert.
I have, after this, 3 more questions.
Can you repeat the last question?
Oh,
We
sorry.
asked you to repeat it.
How many I had. What did you observe regarding the prevalence of voting fraud in Wisconsin, Arizona, and Montana?
I observed that voter fraud was rare in all of those states. And, excuse me, I didn't notice in Arizona and Montana, because those are the 2 states that had the natural experiments that I discussed, I mentioned. I don't see any evidence of a change in voter fraud related to ballot delivery before and after. So for example, I did not observe a lot of voter fraud beforehand and then none later, which would have been consistent with the idea that these laws changed the rates of voter fraud.
So what conclusion did you reach about the relationship between ballot collection laws and voter fraud?
I haven't seen any evidence that there is a relationship on those 2 issues, between those 2 things.
Now, I mentioned earlier that you wrote an article about the North Carolina 9th congressional election that was ultimately overturned because of fraud. Can you tell us what happened there?
Yes. So my article, which is now in a peer-reviewed journal, is an analysis of voting in the 9th Congressional District in North Carolina. It's actually, well, the article covers lots of other states as well, but I'm just talking about what's called NC9. What happened in that district is that an individual created a conspiracy involving multiple other conspirators. I'm using these terms as a layperson, but that's effectively what happened.
Counsel and Doctor, I appreciate, I think that we know what the court and the North Carolina legislature found to have happened in North Carolina.
Okay.
And I appreciate that this witness has a wealth of information to share with us. But my understanding really is that there is not a serious assertion on the part of the Attorney General or the Secretary of State that voter fraud, as defined by this witness, is common or causally connected in those cases where it has been studied to whether there was, quote, voter assistance or not. I think the issues are fairly narrow. I was hoping, Mr. Gill, you'd tell us, because this is not, you know, a trial where we're trying to, just tell us what the area of contention is, then we could make use of the witness's time focusing on that. It would have actually been great to have just admitted his report and then cross-examined him about it, but that's not how it happened. So the report is not in the record.
No, certainly, Your Honor. My concerns specifically were what other knowledge or expertise Dr. Herron might claim in Michigan elections, and further the proposal between voter assistance.
Sorry, sir, Mr. Grill, you went out. And I did
I'm
not-
sorry.
And
I'm sorry, you're right. Where did you lose me?
I'm trying to tell you. And further and then your sound went out.
Okay. Further, I had some additional questions concerning the methodology and the links between voter collection and specifically.
I'm sorry, Mr. Grill, your words went out again.
Voter collection specifically.
Correct.
And something he said specifically.
Voter collection
And fraud.
and fraud. He hadn't gone on to finish it. Okay, I wish that was real specific, but it wasn't. So please continue.
I have one last question for you, Dr. Herron. Does the North Carolina incident influence your opinion about the relationship between ballot collection laws and absentee ballot fraud?
No, it doesn't, and I'll be very brief here. As I've mentioned that my report covers a number of states, 2 states whose laws changed to make ballot delivery illegal, 1 state that didn't change at all, Wisconsin. Obviously, Michigan is in that case as well, and North Carolina is a state that also didn't change its laws. The one place that I observe the sort of voter fraud that we're talking about is precisely in the state that makes it that ballot delivery illegal. And so I think if one has a theory out there that these laws making ballot collection illegal affect voter fraud, I would say I see no evidence in the states that I've reviewed that is consistent with that theory.
Thank you, Dr. Herron. I'd like to move the Dr. Herron expert report, which was attached to our August 17th supplemental filing into evidence as an exhibit.
Your Honor, I think the report is already in the record as attached to the plaintiff's motion. As far as the admission of it here to this TRO proceeding, it wasn't included as part of the motion or anything up until this point, and I'm not prepared to accept it at this stage.
This is a hearing on our request for preliminary injunction, and we attached it to our papers briefing this request for preliminary injunction.
That is correct. That was received 2 days ago. I suppose, Your Honor, I don't have an objection, Your Honor.
It's admitted. Your witness.
Thank you, Your Honor. I'll try to get through this as rapidly as I can here. Dr. Herron, how many articles have you published in total?
I don't have my CV in front of me. I'm only looking at the Zoom screen. I believe I'm confident the number is more than 20. I don't know the exact number.
That's fine. Of those articles that you've published, how many dealt with the occurrence of voter fraud specifically?
I would say 2 of them.
Okay. And how many of those concerned voter fraud in Michigan?
Well, one of the articles was about allegations of voter fraud in the United States, and so that incorporates Michigan. The other article was about North Carolina, as I was talking, and that article included data from a lot of other states, all the states that I could gather data for that were relevant. I do not believe that Michigan was one of those, but I'm not sure. I believe it was not.
Fair to say that neither of those 2 articles dealing with voter fraud specifically focused on voter fraud in Michigan?
Well, I think the first article was about the United States, and Michigan is part of it. And my data covered the entire country, including Michigan data. And I can tell you, we looked at, in that paper, which my co-authors and I looked at individual counties, and we studied to see whether there were unusual states and counties. And Michigan was definitely one of them, because all the states were. And so I would not agree that that report doesn't cover Michigan. It does.
And that would be a great subject, Mr. Gill, for your closing argument on what this proof is.
All right, I'll move on, Your Honor. Doctor, for the 2016 article and the article about the North Carolina 9th, what sources of information did you rely upon?
We rely.
In summary, not specifically.
I would say many sources. For example, I'll just talk about the paper on fraud in the United States. We relied on data from jurisdictions across the country. When we found some unusual features, I believe in Texas, we had to read about what happened in Texas to try to generate some idea of what might explain our findings.
Doctor, I don't want to interrupt you, but just for the sake of trying to accelerate this proceeding here, what general sources of information did you rely upon for those articles that you didn't use in your expert report here for Michigan?
I'm sorry, could you explain that one more time?
Sure. I'm prepared to accept, sir, that for your articles on the general election in 2016 and specifically for your article on the North Carolina 9th that you relied on a number of sources. What kinds of sources in terms of general categories did you use for those two articles that you did not use for your expert report here concerning?
Okay, I think I understood that.
You say concerning. Hello, Mr. Grill.
Yes, sir. Yes.
Concerning something at the end. You went out on my end.
Okay. Dr. Herron, what general source of information, like specifically databases or public records, did you use for the two articles that you published that you did not use for your report here regarding Michigan?
Okay. I would say that those two papers used a variety of statistical sources of data on election returns, and I'm using returns in a broad way here that I did not incorporate directly in my study of Michigan.
And you talked about your research here in Michigan consisted of your assistants reviewing newspaper articles, searching for newspaper articles, and you also made reference to a heritage database. What information is contained within the heritage database?
Well, I mean, I can't testify for what the heritage, I can only tell you what I observe. And what I observe is that it's an attempt for this private group to generate or to create a database of voter fraud incidents.
Right, drawing from newspaper articles, court records. What's your understanding of where the heritage gets its information from?
My understanding is that they draw from all sorts of records. And in fact, I'm confident of that because I have read some of the things to which they cite, and sometimes they're court records, and sometimes I believe they're other sources. I don't have any involvement with that database. My involvement is to use it in order to make sure that the scope that I had was as broad as possible.
What was the cutoff date for your search of newspaper articles about voter fraud in Michigan? What date did you stop looking for new articles?
I tried to do 2012. The only complication is that in some instances, and this actually speaks to the question of sort of how far back one can go, newspaper archives either don't exist when you go sufficiently far back, or I think there might be questions about coverage. So my research assistant, I instructed her to stop at 2012, but even that I think is slightly not the case because she found a variety of instances. These are all documented in my excerpt report about incidents of voter fraud that predate 2012 that happened to be discussed after 2012. And I told her that she's to include those also in the material that she sends to me. And again, that's so that I had as broad a sense. I didn't want her making decisions as to what counts or not. So I told her anything that you find from 2012 to 2020, I need to know about.
And I apologize, Doctor. I think my question was imprecise. I meant, what was the most recent article that you would have seen in your research?
I'm sorry, that I would have seen?
Right. When did you, your search could only have gone up to some point in time, from 2012 up to a more recent date. It's the more recent date I'm asking. When did you stop looking for articles?
Those dates are actually in my expert report. The work that was done was in September. I'm not looking at my expert report. I would suspect that it's August. It could have been late July. I don't recall.
Right. Sitting here today, do you know if it included the July 31st newspaper article about the woman who forged a signature on an AV ballot application that is referred to in the defendant's brief?
I do not know. I would have to confirm with my expert report.
Okay. And you did not review any court filings as part of your report, correct?
No.
Okay. Did you send any FOIA requests to local prosecutors?
No, I did not do that because I was concerned about timing here.
Okay. Was your review limited to absent ballots, or did it include all instances of voter fraud?
It included all incidents. When I gave my instructions to the research assistant, I told her I wanted to know everything she found about voter fraud. And it didn't matter whether it was absentee voter fraud or in-person voter fraud. Yes, and you can see from my exit report that it's completely general in that sense.
Okay. And so if we're talking about a span of time between 2012 and today, it's fair to say that for that period of time, the voter assistance that we tend to talk about as a shorthand in this case was in effect that entire period. Is that fair?
I would say that's fair.
Okay. Okay, so I know you're not a Michigan resident, is that correct, sir?
I am a resident of New Hampshire. That is correct.
Okay, but you are aware that in 2018, Michigan changed its requirements for absent voting?
Yes.
Okay, and that 2020 then is the first election cycle in which Michigan will allow no reason absent voting. You understand that?
Yes, I mean, it's often called no excuse, not no reason. But yes, I understand that. That is.
Okay. And what data did you include to address voter fraud in the 2020 election cycle?
I relied primarily on Secretary Benson's comments. And I, and my research assistant looked as recently as she could.
Okay. Your report, you also discuss Michigan, Montana, Wisconsin, and Arizona. And I think I understand why you chose those states, but just for the record, sir, why did you select those 3 other states?
I selected Arizona and Montana because those were 2 states that had changed their election laws to make ballot delivery or ballot collection or the form of voter assistance we're discussing. They restricted it. They went from a more permissible state to a less permissible state. And as I described in my testimony, that's a natural experiment that is useful for me. And I selected Wisconsin because it is a state that didn't have any changes, but nonetheless allowed for ballot collection in the period of interest, ballot delivery. And that's useful for me because it's a state that if there were significant problems with ballot delivery, you might expect to find them. You could call this sort of I wouldn't say easy case, but in some ways, intuitively speaking, that would be a good place to look for evidence of like widespread absentee ballot fraud in a place like Wisconsin. It also occurred to me that Wisconsin is another Midwest state, which is nice, but I wouldn't say that was completely driving my choice.
Is there any data or is there any state you're aware of to look at in which the ballot collection laws were relaxed?
I don't know all the laws across the states in that period, so I don't know.
Okay. As part of your review here, why did you not look at other states like Illinois, Pennsylvania, or Ohio with populations and voter makeup similar to Michigan?
I actually have looked at Pennsylvania for other litigation, and I can talk about that if you want me to and I'm allowed to.
I guess my question specifically, why was that not part of this report? Why did you make that choice?
Because I needed to do things expeditiously. I wanted states that changed their laws. And I mean, in some ways, those are the most, well, I don't want to say most probative, but certainly very probative states. And Wisconsin, I chose because it's a state that is more permissive. And yeah, those, I mean, I recognize that, you know, in a time environment, I have to make choices about the states I'm going to use. So I wanted to ensure that the states that I analyzed covered the types of states that were of interest to me. And so I drew the line at those three.
In what ways are Arizona, Montana, and Wisconsin, the populations of those states similar to the population of Michigan?
I would say they're states that have elections. They, you know, states vary by population and they vary by rules. That's well known. And this is why I, in fact, looked at multiple states. So I can't tell you, nor can I tell you in general, why any state is in the exact comparable state for Michigan, but what that means is that it's incumbent upon me to look at multiple states, which is why I did. So even Arizona and Montana are two states of the same type. So I would argue that because states vary in the ways I just discussed, I should just look broadly, which is what I did.
In a similar vein, Doctor, in what ways are the political histories and political practices of Arizona, Montana, and Wisconsin similar to those of Michigan?
Really, Mr. Gill?
Your Honor, I guess if we can accept the premise that the states are not particularly comparable in those respects, I can move on.
Can we accept the premise that it doesn't matter?
I can move on, Your Honor.
Okay.
And Doctor, your review of election fraud in Arizona, Montana, and Wisconsin was similarly restricted to a review of newspaper articles in the Heritage database. Is that correct?
And also to the extent that I could find government documents about reports of voter fraud as well.
Okay.
Counsel, perhaps it would be helpful. Let me at least state, since I looked at this, the Heritage database is a listing of some 1,300 instances where the Heritage Foundation has reported that there was some evidence of voter fraud, either by a criminal conviction, a governmental report, or otherwise. It starts at 2020 and it goes back to 1987, with 2 cases listed as having no date whatsoever. Okay.
Doctor, there was discussion in your testimony on direct examination regarding ballot collection, and I just want to explore, are you familiar with the practice known as vote harvesting? Is that the same thing as ballot collection?
I'm familiar with that pejorative term that is used by some people. I don't use it, so I'm not sure how I can answer that question.
Is vote harvesting a form of voter fraud?
I define voter fraud in my testimony as an act of intentional deception aimed at subverting electoral processes.
Okay. Could the mass collection of ballots be done with fraudulent purposes?
I would say that if any action is done in an election with an intentional attempt to deceive in order to subvert electoral processes, that would fall under my definition of fraud.
Okay, so inducement, failure to deliver or destroy ballots after they're given, that kind of a thing?
I would say, I'd return back to the question I answered before. My definition of fraud is an intentional act of deception aimed at subverting electoral processes.
And inducing people to vote in a particular way, is that a form of deceptive practice?
What do you mean by inducing?
Pressure, extortion, bribery.
So that would be coercion of some
Coercion.
sort?
And coercion, yes, Your Honor.
Coercion or bribery? Okay.
Would that be included, Doctor?
I'm a little hesitant to make a statement in a court about coercion in the sense that I don't know the line between coercion and encouragement, how that works legally. I imagine, again, saying this not as a lawyer, that bribery is illegal independently of election law. Again, I'm making this statement not as an expert about bribery. So I would say that given all those caveats, if bribery were used in the way that you're describing, and there was an intentional attempt to subvert elections, I suppose that would count as voter fraud, yes?
Similarly, the willful destruction or the failure to deliver ballots, would that also be considered fraud?
What do you mean by willful destruction?
You give me your absent ballot and I throw it in the trash.
You mean a completed ballot?
Yes.
Yes, I would say that that to me is intentional deception aimed at subverting electoral processes.
And
Mr.
how
Gill,
would
if it helps you, I'm prepared to find that a practice that subverts the voter's intent, either by delivering a ballot the voter did not intend to have delivered, changing the contents of a ballot, destroying a ballot, intentionally delaying the delivery of a ballot, would all be actions that were done with a willful intent to subvert the voter's intent. That offering compensation or threatening a voter who does not vote in a certain way, or who is threatened or coerced or paid to vote a certain way, would also be within the confines of what this court would consider subversion, an intentional subversion of voter intent. All that.
Okay.
And that almost any, you could assist a voter and take a ballot, or you could assist a voter and then fail to do what the voter said. A lot of stuff could happen.
And Doctor, were those types of fraudulent activities included in your review of Michigan cases?
I would say so. I mean, if there, you saw from my exit report the terms that I used, and to the extent that those sort of situations that you're describing were labeled voter fraud or the other terms I used, then they would be included.
Generally, would you agree, sir, that those types of voter fraud are difficult to detect?
You know, I don't work in the Secretary of State's office. I think, you know, what Secretary Benson said, and again, I can't quote this directly because I'm not looking at my expert report right now, but in the comment about infinitesimal, she had a statement, again, paraphrasing, when voter fraud occurs, we catch it and we prosecute it. Again, please understand I'm paraphrasing. So I understand that that this is an important issue for Secretary Benson, as it is in other states with their specific offices or units, I would say, in Secretary of State's offices that are there to make sure the laws are followed. So I mean, I don't think I can comment on how those work. That's an internal government issue.
And lastly, Doctor, you acknowledge in your report, do you not, that scholars agree that the rate of fraud is not zero. Is that correct?
I apologize, I missed one word in that sentence.
No, sure. Let me try rephrasing it too to avoid any ambiguity. In your report, you acknowledge, do you not, that scholars do not assert that the rate of fraud is zero, correct?
That is correct. Scholars, I think, are completely clear about this, that voter fraud is rare, but the rate is not literally zero.
Just one moment, Your Honor. I have nothing further, Your Honor. Thank you, Doctor.
You have anything in rebuttal? Not rebuttal, I'm sorry, in redirect.
No, Your Honor, I just moved for Dr. Herron's admission as an expert witness providing testimony on the prevalence of fraud in the United States and in Michigan, and on the relationship between fraud and ballot collection laws.
That's letting a horse out of the barn after it's burned down. The testimony was received by the court. Does the plaintiff, I hope I know the answer, but my understanding is the plaintiff has no further witnesses. Is that correct?
That is correct, Your Honor.
Okay, so after an hour and 40 minutes, what would you wish to say, if you feel compelled to say anything more than you wrote, about the quantum and quality of the evidence that's been submitted to this court, upon which you would have this court find, aside from the legal question, well, I guess we have to do that first one, that there's a substantial likelihood of success on the merits of the claim, and that the other criteria for injunctive relief have been met.
Thank you, Your Honor. With respect to the likelihood of success on the merits, I want to highlight a few things for the court and point out, first of all, that the evidence that plaintiffs have presented is largely undisputed and unrefuted. I would also like to point out the evidence in the public record that even the Secretary has admitted to. In my opening, I pointed to the 6,405 ballots that have been rejected. Also pointed to the July 29th, 2020 letter from the USPS instructing Michigan that its laws regarding the deadlines for absentee ballots are incompatible with the USPS's service standards. I want to stay on that for a second, because when the USPS was talking about the incompatibility between service standards and the Michigan laws, the USPS was not talking about delays. The USPS was talking about its regular service standards, which is 2 to 5 days for delivery. So Michigan law does not even comply with the USPS's regular standards. Now, we bake in the operational changes and policy changes in July that have caused delays that everyone has acknowledged, including the state of Michigan, in their lawsuit against the USPS and Postmaster DeJoy. When you bake in those delays to what was already a failure to meet the delivery standards, with what was already an incompatibility with the service standards, what chance do voters have who are submitting their ballots in the last week of an election? What chance do voters have who are mailing their ballots in the last 2 weeks of an election? And I understand that the Secretary and maybe interveners or proposed interveners or maybe amici will suggest that voters can just vote in advance and they just vote as early as they want to. Well, I'll respond 2 things to that. Michigan law gives voters the right to vote absentee 40 days before the election, up to 40 days before the election. And being able to vote absentee within 40 days up to an election includes the right to vote absentee within the last week of an election. But beyond that, our witnesses tried that. Ms. Babb tried voting early. She didn't receive her ballot until the day of the primary election. Irene Command tried voting early. She didn't receive her ballot until it was late. In other words, we are presenting voter after voter who is demystifying this process and debunking this myth that everyone who doesn't vote until the last week is lazy. It's not about laziness. There are things that require voters to vote during the last week, and it is the state's obligation to protect.
Counsel, I appreciate this argument, but in talking about this argument, what I think you probably need to address is why questions about the law as written, which was found to be constitutional by the Court of Appeals, why we should be even listening to that, because all that I can do is look at whether or not an as applied challenge survives. The as written challenge, that ship has sailed. Perhaps another court will look at it differently. But as of this moment, whether I agree with the Court of Appeals or not, doesn't matter. I'm obliged to follow it. So League of Women Voters said, in essence, that the requirement that votes be counted only if they are received by the close of the election day was in fact legal and constitutional. They indicated that the requirement that postage be appended and paid for by the voter was in fact constitutional. So what I need to hear from you is something that says there's something beyond that, the mere words, that this court could make a decision on following precedent, which I am required to do.
Certainly, Your Honor. The first thing I would point to is the fact that the League of Women Voters opinion made reference several times to the fact that the challenge was a facial challenge. In other words, the mandamus petition asserted a facial challenge to the law as written. We are asserting an as-applied challenge based on the circumstances.
I got that. That's my point is, illuminate for me, who's clearly not the expert in this subject, what proofs I have before me that says beyond the words, what is it that I know and can make a finding of as a fact finder and then legally, that would say that as applied, there is an impermissive restriction on the right to vote, either constitutionally or otherwise?
Certainly. So as applied to this instance, you have a report, an affidavit from Dr. Eisenberg, which explains the effect of COVID-19 on Michigan, specifically the electoral process. Dr. Eisenberg's affidavit explains how the dangers or the health risks posed by polling places. And for individuals who are at risk or who are at high risk, like the Alliance for Retired Americans members, and many other individuals like Ms. Babb who are at high risk, voting at a polling place may not be an option. Submitting a ballot in person may not be an option. So the incidence of COVID-19 in Michigan, the effect of COVID-19 on the options that voters have in submitting their absentee ballots, and its effect on the ability to vote absentee, whether within 40 days of the election as required under the Michigan Constitution, or just to exercise one's right to vote, has been upended. And numerous courts have already recognized that. And under normal circumstances, the League of Women Voters opinion would be binding on constitutional challenges, but these are not normal circumstances. We're not under normal times. We're in a time where not only has this disease or this virus ravaged the state and the political process, but we're also in the middle of operational upheaval by the government entity that is primarily responsible for delivering absentee ballots. And when you have those two incidents combined, you have abnormal external factors that have changed the dynamic and that are proven, are not disputed, and that impose an additional burden on the right to vote and the right to vote absentee that was never contemplated by the League of Women Voters opinion. And I would point the court to all of the examples in which this has happened. For instance, a voter registration deadline is not by itself unconstitutional. States have voter registration deadlines and people abide by them. But when a hurricane comes through, courts do not hesitate to find that a voter registration deadline may impose an unconstitutional burden. That happens in Florida. Florida Democratic Party v. Scott, the Northern District of Florida, back in 2016, had found that imposing the voter registration deadline in the aftermath of Hurricane Matthew potentially violated the constitutional rights of voters. Now, I know that's not a case we've discussed at length, but it's just one example. This happens all the time where there are deadlines, but then there are external events that cause those deadlines to impose unconstitutional burdens as applied. This court similarly found in fair and equal elections, I believe in July, that the 180-day deadline for collecting signatures or the 180-day expiration period for signatures on initiative petitions, that had to be told. And I believe this court told that deadline for over 60 days, not because the 180-day time frame was unconstitutional by itself, but because the events of COVID that transpired since COVID-19 hit our shores required some accommodation in order to protect those constitutional rights. And we're asking the court to make that same observation here. We're asking the court to make that same observation based on the unrefuted evidence that we've presented. And I'm happy to very briefly go through that evidence because it is voluminous and it's all undisputed. I was talking about the operational difficulties USPS is having. That is undisputed. Michigan has sued Postmaster DeJoy because of those difficulties. Everyone has acknowledged that it is causing delays. In addition to that, we talk about the prepaid postage issue. There are, of course, individuals who can afford postage and have postage available, and there are others who cannot. For those who cannot afford postage, what does this pandemic do to the cost of acquiring postage? Now we have unrefuted testimony from Dr. Ken Mayer, who explains how the costs start to accumulate. Not only do you have the cost of purchasing postage online, but the cost of actually venturing out, subjecting oneself to health risks and procuring the postage. And then when we talk about the evidence of COVID-19 and the lack of timely mail delivery, all of these challenge laws are interconnected. Because if you can't vote in your polling place because you're at risk and you're concerned about contracting COVID, and you are then forced to incur the cost, and again, not just the cost of the 55-cent stamp, but all of the ancillary costs of purchasing postage. And on top of that, you have to rely on a family member or an in-law or a county assistant in order to deliver your ballot. Well, that severely restricts your ability to vote during the COVID-19 pandemic in an election, in the first general election to be held during this pandemic. Those are events that are specific to this case. Those are considerations that were not before the court in League of Women Voters. And those are all factors that should lead this court and can lead this court to grant us relief on our as-applied challenge. And I would point out that an as-applied challenge asserts that the court should prevent the future application of these particular laws in the same context or in similar contexts, not to hold it inoperative. And these events and this unprecedented crisis that we're under is the type of intervening event, like a hurricane in Florida, that requires the court to take additional measures to protect the constitutional right to vote. Now, I want to address a couple of points that have been raised, both in testimony and previously in arguments. One of them is the Purcell point, whether the court should grant relief within this certain proximity to the election. And I would point out to the court, specifically with respect to the ballot receipt deadline, that courts have actually granted this form of relief on election day. Now we'll start with the highest court, which reviewed a decision, highest court being the US Supreme Court, which reviewed a decision from Wisconsin on the eve of an election and the decision from Wisconsin extended the ballot receipt deadline by 7 days. The U.S. Supreme Court did not issue any edicts about not extending the ballot receipt deadline, and that was the same U.S. Supreme Court that obviously published Purcell. Now I want to point the court to 2 orders from courts of common pleas in Pennsylvania in the June 2nd primary, in Bucks County and Delaware County. On election day, by 3 p.m., they extended the ballot receipt deadline for 7 days. 3 p.m. on election day. We are 2 months out from election day, and the secretary is suggesting that it's too late to extend the ballot receipt deadline. That's hard. That's a hard pill to swallow. And that's not the only example. There are numerous other states. Georgia, just a couple of days ago, just extended their ballot receipt deadline. And not only are states recognizing the need to provide these accommodations, but they are also uniformly rejecting this idea that it's too late. Now, I want to move on quickly. I know the court wants to keep things moving, and I want to briefly address the notion that the ballot assistance ban somehow is necessary to prevent against fraud. And I want to point the court not only to the absence of voter fraud, and not only to the fact that other jurisdictions allow it, but to the fact that it's already permitted. And it's been permitted for quite a while. And the notion that ballot assistance, that the reason that it hasn't led to any fraud is because it's prohibited, well, that doesn't explain why it hasn't why we've seen no fraud with respect to the categories of individuals who are permitted to return ballots. Then I'd like to ask the court to look very carefully for any actual connection drawn in opposing counsel's brief, in the secretary's brief, between ballot delivery assistance, and fraud. The reason they can't draw that connection is because there's nothing fraudulent about delivering a ballot. What is fraudulent, if any fraud happens, is the accompanying subversion of the electoral process that may result in tampering or perhaps even coercion. Now, it's interesting that during opposing counsel's questioning, he made a reference to the fact that when people collect ballots, they may intimidate others, or they may coerce others. I believe MCL 168.932G and H make it a felony to suggest or in any manner attempt to influence a voter filling out an absentee ballot. So what additional incremental benefit or protection does a voter assistance ban provide other than restrict voters from being able to obtain the relief that they need? In other words, the restriction on ballot delivery, period, is a prophylactic measure. Narrowing the scope of individuals who can return ballots is a prophylactic measure, because none of those actions would actually result in fraud absent some other unlawful act. What the secretary and the state is doing is stacking prophylaxis upon prophylaxis, which is not the type of regulation that can pass constitutional scrutiny when it violates the right to vote, when it prevents individuals from accessing the franchise. Now, in terms of the timing of relief for the voter assistance ban and the timing of relief for prepaid postage, we've already established that the extension of the ballot receipt deadline can happen even up to election day, and frequently does. With respect to the other forms of relief that we're seeking, there is no upheaval of the election administration process here, because those actions are in place as we speak. In other words, if ballot assistance were made available to people beyond the scope of the limited categories of individuals in the statute, the county would just conduct the same procedures it conducts when allowing in-laws to drop off ballots. When an in-law drops off someone's ballot, what does the in-law have to do to demonstrate that they are an in-law? I'm not sure what that could be. Chances are probably nothing. In other words, what I'm saying is the state has procedures in place to accept ballots from individuals who neither live in the same household nor share the same last name as the voter. Why can't those procedures be applied broadly to individuals whom the voters trust and whom voters decide that they feel comfortable returning their ballot? Why does it have to be limited to family members? Why does it have to be limited to in-laws? There's nothing in the election administration process that would create any difficulty from expanding that scope of individuals who are permitted to return ballots from in-laws to friends, neighbors, and individuals who voters trust. And then we talk about prepaid postage. Whatever administrative difficulty that the secretary may propose that would prevent the court from implementing such relief is a canard, because counties or city and township clerks right now, as the secretary admitted in her brief, are in the process, at least some of them, of making decisions about providing prepaid postage. In fact, the secretary anticipates that more counties or more city and township clerks will decide to provide prepaid postage. Now, not nearly enough, especially given that the secretary is reimbursing these costs, but the secretary anticipates that more clerks will in the future make that decision. So if it's not too late for clerks to make the decision on their own, then why is it too late for this court to grant relief? Why is it too late for this court to issue an order that requires them to do something that will literally cost them nothing? Because the secretary has already agreed to reimburse these costs. So when weighing the burdens to voters and the harm to the state under the Anderson verdict test, it's not enough to say the burden is slight, because case after case has said, however slight the burden is, it must be justified by a state interest. There is no such thing as a burden that needs no justification. The secretary may try to undermine the burden that some voters will encounter in providing postage. Ken Mayer has outlined those burdens. The secretary has not refuted them. But what the secretary needs to do is to come forward with the actual state interest that justifies that burden. In the League of Women Voters case, it was finances. That's no longer the case. So without the financial burden and without that restriction, what is it exactly that would be so burdensome to provide prepaid postage now that it has already been paid for? And if we want to talk about timing, I would ask the court to look into the events, right, and to look closely at the events that will transpire within the next few weeks. For instance, within the next few weeks, Michigan clerks will be sending out UOCAVA ballots to military and overseas voters. Well, those are required by federal law to be accompanied with prepaid postage. So nothing different is going to be happening. In other words, there's not only sufficient time to afford relief, but there is no justification not to afford relief. And the burdens that voters will encounter because of these challenge provisions have been laid out in affidavit after affidavit, in expert report after expert report, and through numerous stories that both stories that we've presented and stories that even the secretary has presented, and by the August 4th primary, which demonstrated that 6,405 voters had their ballots rejected after the deadline because their ballots were delivered after the deadline. That is more than almost triple the amount of voters whose ballots arrived after the deadline in the 2016 presidential election. And this was just a primary. For those reasons, Your Honor, plaintiffs request that the court grant the renewed motion for a preliminary injunction. And to the extent that this hearing is intended to cover the motion for summary disposition, plaintiffs would request relief on that motion as well. Thank you.
Ms. Meingas?
Yes, Your Honor. Principally, I'm happy to rely on the briefing that the court's already reviewed. I think, I would just note that I'm not, as far as the testimony that we heard today, I'm not sure that it added much to the conversation with respect to the absent voter sort of delivery assistance statutes, which is principally what we've raised in our brief.
Ms. Meingas, I just want to make sure that we're clear on Michigan rules. Your colleague has asserted that the affidavits that they filed, which certainly could defeat a summary disposition motion in certain circumstances, but that the affidavits and reports that they filed are, quote, unrefuted and are evidence for the purposes of this court making a determination in this case. Is that also your position?
Well, I guess, part of the, let me think.
Not as to summary disposition. but
Yeah, I
as to
mean,
injunctive relief.
I would agree that they're unrefuted in the sense that we did not have time to attempt to obtain expert testimony and affidavits of our own. But I'm not sure, from my perspective, the affidavits, the news article, I mean, they're as compelling or as supportive as they are. And from my perspective, they're not. I mean, they don't turn the tide with respect to
The question
the
was,
issues
the question was discrete.
Okay.
You believe that this court could make findings of fact as to irreparable harm and substantial likelihood of success on the merit to the extent that there are factual questions underlying that based upon affidavits.
Yes, I think you could make preliminary factual findings based on the evidence that the court currently has before it in this injunctive phase.
So you would consider that this is, I admit, I teach evidence. This is for this, I'm asking you this for a reason. You would consider the affidavit to be admissible evidence for the purposes of this court making a factual determination.
Yes, I don't dispute their admissibility for purposes of for purposes of what we're doing.
Okay. Please continue.
All right. Right. So I think principally I would just offer a few comments on what we heard from the testimony today, and I'm not sure that it added much to the dialogue, particularly with respect to the absent voter delivery assistance statutes. With respect to Miss Babb, she was able to vote in the August 4th election. There doesn't seem to be any reason why. She's already indicated she has assistance lined up for a November election. With respect to the March primary, I do understand that she received her ballot late and was not able to return that. Certainly there seems to have been things that could have happened before then that did not, that might have avoided that by following up earlier to get an additional ballot or to ensure that her ballot was arriving timely. I know, and actually calling and asking for assistance on election day. She said that she called to complain about not receiving her ballot, but she didn't indicate that she had asked for assistance on election day. And that is something that voters can do on election day, is to request assistance from clerk's office still the day before. So, the testimony is what it is. It also demonstrated that she does have family support. She does have somebody who can return her ballots. And she, we also have the situation with the drop box. Drop box can be used at any time, day or night, as long as it's, in there before election day. And she agreed that, she could be driven to the drop box potentially by a friend that would work. And also her family members, to the extent they work through business hours, the drop box is another way of returning a ballot. And, the drop boxes are prevalent. And she knew where the clerk's drop box was. So, so the testimony, it is what it is. And I don't think that it leaned particularly tipped in favor of plaintiff's points here with respect to the absent voter delivery and assistance. With respect to Dr. Herron's, testimony or his expert report, as you saw from our brief, we don't disagree that there is not widespread fraud in Michigan, right, with respect to any kind of voting procedure. But we don't have to show that, right? If you look at the In re advisory opinion from the Michigan Supreme Court, it specifically states right in there that the state need not provide proof of widespread fraud or even necessarily any. It is, protecting the integrity and security of the election process is a compelling interest, and the state's not required to put forward proof of widespread fraud or even small amounts of fraud. But we do have to, I would agree that we have to prove a connection between the regulation and what we're what we're hoping to prevent, the unscrupulous practices or the fraudulent practices that it's designed. And I think the collection, you know, they want to focus on the delivery aspect, but it's the collection part. I mean, the only way you get a ballot into your hands is to show up at a voter's door or to come by and you collect it from them. And as we pointed out in our brief, our July 3rd brief, you know, this statute was specifically amended in '95 because there was unscrupulous practices with respect to third parties collecting ballots. And that's right in our brief, and that's right in the legislative analysis. Now, is that court proof? Is it overcharging? You know, no, but the legislature changed it in response to reports of problems with this process. So there is evidence, there is proof that it was changed to take out this third-party option in response to complaints from election officials that there were problems with this process. So we do have support for this restriction. And, you know, in response to that is why the legislature, or as we pointed out in our brief, the expansion should be, and the remedy to that is the idea of being appointed. You know, as we said, with plaintiffs, organizational plaintiffs, their members, to the extent we're concerned that people will have trouble getting someone to pick up their ballot. They don't have family and they don't have, you know, a household member. You can call the clerk. The clerk can deputize as many assistants. It can deputize all the Michigan Alliance for Retired Americans members in a particular community to assist with ballot pickup. So there are other options. And of course, if you don't have a family, I mean, there's still other options for a voter to return. So the burden, even under the present conditions, because I'm not really sure that the pandemic affects this process. I mean, how I see it, the pandemic is what we all would probably agree, probably the cause for why we will received increased voter usage of AV ballot applications. But it doesn't necessarily impact these other processes for delivering, you know, postage, delivery, all of those processes. So with respect to, so I'm not sure, and then going back to Dr. Herron's report, right? I mean, we don't disagree, but there is that there's not widespread, but we don't need to show it. And we have proof in the record and we can show a connection. So I think with respect to that, plaintiffs haven't met their burden of showing that there's no support, or that this isn't a minimal burden that's at least outweighed to the extent necessary with respect to the state's interest in preserving the integrity and security of the process. So I don't think that moved the dime. And so to the extent there's claims that it's unrefuted, it's because it doesn't move the dime. It doesn't move the ball forward from my perspective. So with respect to the, sorry.
Yes?
Oh, I thought you had a question.
No.
Okay. With respect to the postage receipt, or excuse me, the postage required element, again, we do have a state interest in that requirement that voters fund their own postage. I mean, the legislature, I mean, we have the case in our brief, financial considerations have been taken into consideration under Anderson verdict. It's a reasonable state interest. The burden here is minimal to provide postage. Ms. Babb said she had postage. So the question is, what is the state interest? Is the state's interest sufficiently substantial enough to outweigh that minimal burden? And the courts have recognized that financial interest can be. And so here the legislature decided many, many, many years ago, a long time ago, right, to shift some cost from the locals, right? Because the locals fund this, the state doesn't do this. The money comes from the locals to pay for postage. And this legislature determined that we're going to shift this small cost onto the voter. Similar to my cost for when I drive my car, to go vote in person. They've shifted a small portion of cost onto the voter to help ease costs and burdens on the local governments. And so that's the reason behind it. And it's been that way for a long time. And so that's a sufficient interest that outweighs the minimal burden imposed by the postage requirement. This whole focus on the state has the ability through federal grants right now to reimburse doesn't mean that we don't have an interest. that supports the statute in the first place, the requirement in the first place, they still have to show that it's unconstitutional and that we don't have a sufficient interest to outweigh it, and we do. And this whole concept that the secretary, because she has federal funding, this should just be enjoined, I think is a detour. Because first of all, I mean, we can't, you're going to compel us to, it's a policy, you know, we've made a top policy decision to provide funding for those who want it. And if, I'm not sure how an injunction would even work with respect to, you're going to enjoin the state to force money onto the community. And it's not even something that we can really do right now, because how we can use those funds, it's a federal grant. You know, we would have to set up, there's things that would have to happen. So I think the long story short, what I'm saying is it's not as easy as Mr. LaQuanta would say, that simply because we have the funding, you should simply enjoin it. They still have to show that there's a constitutional violation here, and they haven't done that. And as far as with respect to irreparable harm on that point, I mean, you know, we don't know that yet, because there are lots of communities, even taking into consideration what they're saying, lots of communities, even our biggest communities, are already doing this. Oakland County, the second largest county, is already funding. Flint and Detroit already prepay their AV ballots. Other communities are doing it as well. And the expectation would be that more do as well, to take advantage of the reimbursement. With respect to those communities that don't, all those voters in those communities still have all the other options for returning their AV ballot. They can still use family members. They can still use household members. They can still call the clerk. They can have somebody take them to a drop box. So there still remains plenty of other avenues for returning a ballot if the person does not have postage. And I think the problem here with their arguments as well is that I do think League of Women Voters, you know, forecloses a lot of it. When they took into consideration already that financial hardship, you know, was not a sufficient, they rejected that argument as a basis for finding it unconstitutional there. So I think there's a hurdle with respect to that as well. So we've had a long day. I'm not going to belabor the points, Your Honor. Those would just be the couple of points I'd make. I guess I would make, I'm sorry, I'm going to make one further note on a little bit off topic. With respect to the summary disposition, you know, that wasn't noticed for today, and it's, you know,
it's not, it is not my intent to have any oral argument on the summary disposition motion.
I think, but my point would be, Your Honor, I didn't read the order as saying no responses and replies were going to be allowed. I mean, it you know, set a date for filing opening briefs.
And you're right, that is off point.
So, I mean, it seems to me we would still, I mean, respectfully, I don't,
could we finish with this person?
Yes, I'm sorry, Your Honor, of course.
Okay.
Go ahead.
Are you complete with your argument as relates to the renewed motion?
Yes, Your Honor.
Ms. Nuwatu, do you feel compelled to say something else?
Just two quick things, Your Honor, that I want to correct for the record. The assistance that city and township clerks can provide, it's not mandatory after 5 p.m. on Friday before election. So anyone who is in the same position Ms. Babb was in, whether they would have access to that assister is not certain. I mean, there's some counties that would not have that, would not provide such assistance. Second, the fact that individuals can apply to be an assister, the fact that organizations can apply to be assisters, that does not remediate the First Amendment violation, because the choice of whether a city or township clerk appoints an assistant and who that assistant is entirely the city and township clerk's discretion. And subjecting one's First Amendment rights to the unfettered discretion of another party, it does not protect those rights. And that's essentially what the Secretary is suggesting. The city and township clerks have unfettered discretion pretty much in deciding whether to have assistants, how many assistants to appoint, and whether to even allow those assistants to provide the services that Ms. Meingas suggests are available after 5 p.m. on the Friday before Election Day. So I just wanted to clarify those points. I also wanted to clarify that the funding for prepaid postage, we're not just saying the Secretary can pull federal funding and reallocate it. No, we are saying the Secretary has publicly committed to paying for prepaid postage, for reimbursing city and township clerks up to $2 million for providing prepaid postage. So we're not looking for the funds. If the Secretary is committed to paying for this, the financial burden on the state is no longer an interest in preventing this relief, is no longer an interest in forcing voters to secure their own postage, because that is no longer an equation. The funds have already been allocated for that purpose. So for those are the two main areas I wanted to clear up, Your Honor.
You filed an affidavit, and I'm not remembering which of your affiants it was, from a person who votes from a residence in Wyandotte. It's Ms. Williamson.
Yeah.
But is a registered voter. Yes, she's a registered voter in Wyandotte, but a resident of Ontario, whose addresses the issue of the closure of the Canadian border. Why is it that she is not eligible to vote under Americans Abroad?
Your Honor, and it's been a while since we submitted that affidavit, but my understanding was that she is not a resident of Ontario. She's up there with her husband,
No,
who
her
is a
affidavit-
resident of Ontario.
Her affidavit says, which made me wonder what, but anyway, her affidavit says, I have been a registered voter in Wyandotte, Michigan since 1987, though I have been a resident of Ontario since 2014 with my spouse who is Canadian.
I see. So I think she should be protected under UOCAVA, and I think that the main point of her affidavit is that the extension for military and overseas voters is not automatic. The extension only occurs if the clerk was delayed in submitting in sending out the ballots. So if the clerk was not delayed in sending out the ballots, she'd be subject to that same election day deadline. But I think the key point from her affidavit is that by July 31st, her ballot had made its way to US soil. And I believe it was in Illinois, and then made its way from Illinois to a processing center near Detroit. And between July 31st and August 4th, her ballot was not able to get from Illinois to her local election official. In fact, it took from July 31st to August 7th, I believe, which is 8 days to travel from Illinois to Michigan. And I think that underscores the burden that voters face and the mail delivery delays. It wasn't the Canadian border that held up this ballot, at least during the last week. You have that period from July 31st to August 7th, 8 days to get from Illinois to Michigan.
Okay, I see the tracking data now. Okay. I was just at a loss as to why we had that one at all. Okay. All right. Well, I thank you. You have been nothing if not thorough in providing the court with information. As Ms. Meingas, you feel on these motions for summary disposition, I've read them. I don't believe that there is anything that you're going to add in a reply brief, but if both sides want to file a reply brief, realize that in theory, this is just the theory. In theory, this is my month off, right? So, and we don't have a process that says This then goes to another judge. It stays wherever it is. If you wish to avail yourself of reply briefs, I will let you both do so. There will be no oral argument because I think you have argued this case beyond death and beyond the afterlife. As a practical matter, this case probably lives or dies with this injunctive motion. The court will be required to manage the summary disposition because that's how you ultimately close the case out. But pretty much no matter what I do on this injunction is probably going to be appealed. But you want the right to file a reply, Ms. Meingast? How long do you want?
I mean, I guess it's just, with all due respect, you know, without knowing, it's hard, you know, since the injunctive motion, your decision on the substantial likelihood of success would have an impact on, to me, from my perspective, on the resolution of summary disposition motions.
So you're not asking, you're asking for the right to reply after I rule on this and while you're on appeal to the Court of Appeals.
Well, I think as things normally sort of proceed, right, you have an injunction hearing, you have
I said,
briefing.
is that what you're asking for?
I guess that's what I'm asking for. We would have the
Okay,
benefit
Mr.
of your
Nuwaza?
opinion. I'm sorry. I'm not trying to be difficult. I'm just trying
It's
to make
not a
sure
question of whether you're being difficult. You said what you said. You want to have a period of time after the ruling on the motion for summary disposition, on the ruling on the renewed motion for injunctive relief, to file a reply to a motion for summary disposition. Mr. Nuwaza, your response to that position, do you similarly want to have a period of time after the court rules on the second or renewed motion for injunctive relief, after which you would have the opportunity to file a reply to the motion for summary disposition?
We would be willing to waive that, Your Honor. Provided that but if the secretary is given the opportunity to file something, then we would reserve the opportunity to consider it. But we would be willing to, as we sit here right now with no parties filing any briefs, we'd be willing to waive that.
Your motions were due, again, I have to operate on an iPad because the real computer doesn't have a camera. The deadline for the SDs was?
we filed on Monday, or right? Monday, I filed Monday by 9. And counsel, I believe that she filed Tuesday, right?
That's right. And to give further clarification, Your Honor, the original deadline was Sunday.
Right.
And
It was on the 30th.
The way the briefing was structured was that we filed our renewed motion for preliminary injunction on the 17th, and then the secretary was required to file her response on the 28th, and then on the 30th we would file our motions for disposition, for summary disposition. And in light of the secretary's request for an extension, we asked for a similar extension so that we would have that same period, that same 2-day period, to see the secretary's response and see what the secretary was objecting to and not objecting to, because that would inform our motion for summary disposition. And that's
Okay.
why we requested and stipulated to file ours on Tuesday.
All replies will be due on or before before September 25th, period.
Okay.
All righty. And with that, please have a good afternoon. And I'll now do my next hearing on my vacation. Take care.
Thank you, Your Honor.
Thank you, Your Honor. Bye-bye.
See you.